What do you mean there's no earnest money for liquidated damages? Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with the situation. What happens if a buyer defaults on a contract but never turned in the earnest money? Oh my goodness, what happens then? Well, let's back it up just a little bit. Depending upon the contract under which the buyers and sellers are binding, dictates a little bit of the time frames or timing of some issues involved with this. So, under the GAR or Georgia Association of Realtors Purchase and Sale Agreement, the buyer and seller negotiate for the time frame from the binding agreement date, who the holder is, and when the buyer is going to remit the earnest money to the holder. And remit is just a fancy word for send. And it talks about who the holder is. They identify the holder in paragraph A6, and then in A7, the form of the earnest money and when it is supposed to be sent. Under the RE forms contract, which is RE 100, contract for purchase and sale of residential real property, same thing under paragraph 3. It talks about the amount of the earnest money, whom the holder, and they use the word escrow agent for the holder in the form. And then it states, again, that the buyer has not yet remitted at the time of signing the offer, and they agree to send the earnest money to the escrow agent within blank days of the acceptance of the contract. And in the RE forms, that is defined as the binding agreement date. So, back to the question. What happens if the buyer never sends it? Or let's say the buyer sends it, but the bank does not honor those funds, either insufficient funds, or sometimes if the check number is too low, the bank won't honor it. Or there's just sometimes it's reversed. If it was an ACH payment, it could have been reversed. So all kinds of situations happening. So let's go back, and as you've been in any of my classes, you've heard me say that the contract is nothing more than a set of instructions. So let's go and see what the instructions state. Well, under the GAR purchase and sale agreement, it states that not only the buyer and seller negotiate when the buyer has the obligation to send the earnest money to the holder. But then if you look under paragraph B6, under the F201 purchase and sale agreement, it does go on to state that the holder then has an obligation to deposit those funds within not later than 5 banking days after the binding agreement date hereunder, or 5 banking days after the date it is actually received, if it is received after the binding agreement date. So why is there a difference in that? And in the RE forms, it is the standard under which, or the instructions under which the holder or the escrow agent is to actually deposit the earnest money, is 3 banking days from the date of the binding agreement date and receipt of the contract. So that's all pre-printed in those contracts. So if the holder never gets the earnest money, the holder has an obligation to send notice to the parties that either I never got it or it was not honored by the bank, which means I never got it. It has not been deposited into my account. Once that happens, so the holder is supposed to send notice. But remember, there's a little bit of leeway in the timing from the buyer's obligation to send the funds to the holder and the holder's contractual obligation to deposit those funds. Well, you have to account for weekends and banking holidays and times when the holder might not be there to actually make the deposit. Nevertheless, for you in practice, just note that there could be a discrepancy or a little additional time frame from when the holder is contractually obligated to send notice that they have never received the earnest money from when the timing that the buyer is obligated to send the funds. So, and when this happens, just to back up just a little bit, the holder sends notice to the parties, the buyer and the seller, that they have not received the earnest money. Either they never received the deposit or the deposit was not honored by the bank. Then the buyer has the right to cure that default. And in the GAR purchase and sale agreement, the right to cure, again, is spelled out in the purchase and sale agreement, and it is under paragraph B6. And the buyer has 3 banking days from the date of notice to cure the default. In other words, make good on the earnest money. And thereafter, the seller has 7 days to terminate the agreement if they choose to do so by sending notice to the buyer. Under the RE forms, this part is spelled out under the standard terms, which is RE1. And under that section, it is under paragraph 3 in the standard terms. And again, the holder has to send notice and to the parties, buyer and seller. And then the buyer has 3 calendar days from the date of the notice to make good on the earnest money. If not, the seller again has 7 days thereafter to terminate the contract. What does all of this mean for you as an agent? Well, it means a couple of things. Number one, if you are working with a buyer or if you are working with a seller, it is your responsibility as an agent to follow up on the earnest money on both sides, because the buyer is obligated to turn it in, and you want to make sure to keep your buyer from defaulting on the contract. The seller might have a claim to the earnest money should the buyer default on the contract. So it behooves you both to follow up with the holder of the earnest money. Did you get the earnest money? Did you make the deposit? Did you get the earnest money? Did you make the deposit? Did you get the earnest money? Did you make the deposit? Again, it is both of your clients, a buyer side and a seller side, potentially have a claim to the earnest money. Well, what happens if a buyer terminates a contract, and let's say they terminate by default? Let's say they had 0 contingencies, or they terminate after the expiration of a contingency time frame and they never send in the earnest money. Well, a couple of things. Who's responsible? If it was a termination, if it was a default termination, the seller is going to want that earnest money as liquidated damages for the default, per the default paragraph in your purchase and sale agreements. But if it's not there for the seller to get, what happens? Well, whose responsibility is it? And again, you have to go back to the contract and look at the timing of, did the holder fail to send notice, or did it terminate? Did a buyer terminate prior to the holder's contractual obligation to send notice that they never got it? So I was just editing this video, and one thing, an important thing that I neglected to mention is, if a buyer defaults on a contract prior to remitting or sending the earnest money to the holder, so the holder, and with everything I've been discussing, and the holder does not have it to disperse to the seller as liquidated damages, does not mean, that does not alleviate the buyer from their obligation under the contract regarding, or the consequences under the contract regarding default. They still owe that earnest money to the seller as liquidated damages because they did default on the contract. And also, per default, the brokers can still pursue them legally for commissions owed because a buyer still defaulted. So just because they did not remit the earnest money to the holder doesn't necessarily have it to disperse to the seller as liquidated damages, but the seller may pursue the buyer legally for that earnest money as the consequence or the remedy for the buyer's default on the contract. So it's not just free and clear that they get away with not having sent in the earnest money. They have still signed a legally binding contract that does have specific remedies that they agreed to for a default. It's not necessarily the holder's responsibility to have sent notice, because there are prescripted time frames in the contract under which they have to rely on to send that. And sometimes in these quick contracts, we're having very limited number of days on contingencies, and buyers are terminating, and there's no earnest money there for the seller as liquidated damages. So just a contract tip, just a couple of things to keep in mind when you are working with buyers and sellers regarding earnest money and timeframes to remit it to the holder and timeframes for the holder to send notice. Hope this contract tip helped you out. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.